Hi guys, and welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we'll be talking about a rescission of reciprocal obligations. And I want to talk about this today because this is a very important topic. While it is found in Article 1191 of the Civil Code and therefore in the later part of pure and conditional obligations, I wanted to give rescission its own episode because it is very, very important. Okay, I want everyone to understand this topic because rescission is something that you may use in case of breach of obligations. Okay, so if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay, so before we begin with rescission of reciprocal obligations, let's review what a reciprocal obligation is. Okay, a reciprocal obligation is one that is created at the same time and for the same cause and results in the mutual relation of creditor and debtor. In other words, each party to the obligation is now the creditor and debtor of each other because they are bound to perform an obligation in favor of the other. Okay? This is contrasted against a unilateral obligation wherein only one of the parties is bound to render a prestation. Okay? So, I mentioned this because rescission only applies in reciprocal obligations. Okay? Rescission will also only apply in case there is breach. And let's just review what is breach. Breach is failure without legal reason to comply with an obligation. And if you remember my discussion in the nature and effects of obligations, breach may also give rise to damages in case it is attended by delay or default, fraud, negligence, or contravention of the tenor of the obligation. Okay, that's just a review. Okay, so in case of breach, these are the remedies of the injured party. Okay, in case of breach, the injured party may choose either, take note, either specific performance or rescission. Why did I emphasize either? Because these remedies are alternative, meaning the injured party can only pick one. Okay? These two are incompatible remedies. If a party picks one, he cannot pick the other. However, there is an exception which I will get to shortly. Just wait. Now, they are incompatible remedies because a party cannot ask that an obligation be specifically performed. Now, you do this obligation and at the same time ask that the obligation be cancelled. Okay, so in other words, you cannot have your cake physically and eat it too because once you eat it, the cake is no longer there. Okay, so you cannot ask for an obligation to be specifically performed and at the same time ask for its cancellation. So pick one, specific performance or fulfillment. However, there is only one instance when the two remedies may be availed of successively, and that is when, in case the party picks specific performance and then this specific performance becomes impossible, hindi na pwede gawin, no? It's now impossible. Then the injured party may now pick rescission. Okay? That is the only case. The party first picked specific performance, it became impossible, then the party can now pick rescission. Okay? So as a general rule again, the remedies of specific performance or rescission are alternative. Okay? You can only pick one. Okay? Now, let's go to the first important concept, no? The power to rescind is implied in reciprocal obligations. Again, rescission only applies to reciprocal obligations and the power to rescind is implied. In other words, in case one of the parties to the obligations fails to comply with his part, then the other, the injured party, has a right to claim rescission as a tacit resolutory condition. Tacit resolutory condition simply means that there is a resolutory condition that is implied, no? In other words, the obligation will now be extinguished by the happening of the condition, which is the breach. And by happening of the breach and invocation of rescission, the obligation will now be extinguished and the parties will now be bound to return what they may have received by virtue of the obligation. Okay? Now, I just want to emphasize that rescission under 1191 of the Civil Code, what we are talking about now, is different from the rescission under 1381 of the same code, no? Which is for rescissible contracts, okay? Those are two different remedies, no? Because 1381, rescission under 1381 is a remedy for the reparation of damage caused by lesion or fraud. And here in 1191, it's a remedy in case of breach. Magkaiba yun, ha? Let's just give the other distinctions of 1381 and 1191, ha? In 1381, for rescissible contracts, the party who may bring it can be either party to the contract or a third person who is damaged by the contract, okay? But in 1191, only the injured party to the contract may bring the action for rescission. Okay? Only the injured party. In 1381, the law lists several grounds to claim rescission. But in 1191, there is only one ground, and that ground is substantial breach. Okay? In 1381, the courts cannot extend the time to perform the obligation, but in 1191 the courts have discretionary power to extend the time for performance. Okay? 1381 may apply to a unilateral obligation or a reciprocal obligation, but 1191, remember, only reciprocal obligations. And finally, 1381 is a subsidiary action, meaning it can only be invoked or asked for if there is no other legal remedy. But 1191 is a principal action which may be resorted to in case of breach. Okay? Now, let's go to the second important concept about rescission. Okay? Even though the right to rescind is implied in reciprocal ones, even though that right does exist, the right to rescind is not absolute. Okay? Doesn't mean you're entitled to rescind right away. First of all, the right of rescission granted under 1191 is a judicial rescission. In other words, the injured party must resort to the courts to claim rescission. Okay? Because the courts will not only decide if the rescission is proper under the circumstances, but the courts also have the discretionary power to fix a period within which the party at fault may still comply with his obligations. Okay? The courts may say, maybe rescission is not proper. Let's give the party at fault some more time to perform. He might be able to perform. Okay? So, while courts must be invoked, must be called upon to claim rescission, there are exceptions when you don't have to go to courts. Okay? First exception. Remember I said the power to rescind is implied. What if the parties expressly give the right of rescission? That is allowed. Okay? Parties may include a stipulation in their contract that granting the power to rescind extrajudicially, out of court. That is allowed, okay? So in this case, resorts to the courts are not necessary, okay? But take note first. How does this happen, no? The party who wants to rescind must send a notice of his intention to rescind, okay? If the other party accepts that notice of rescission, then we have no problem. The rescission is effective already, okay? It's done. That is in case the parties have expressly agreed on granting the right of rescission. However, no, if the other party receives the notice of rescission and then he opposes it, he says it's not correct, then a resort to the courts must be had. In other words, the parties must go to court and ask the court to decide if the rescission is correct or not. The second exception, when the parties don't have to go to courts anymore to claim rescission, is in case the contract is still purely executory. When we say a contract is still purely executory, there's still no performance on both or either side. Okay? The contract is still executory. And in this case, if the party declares his intention to rescind and it is accepted by the other party, then the rescission is validly claimed. There's no problem. But if the other party opposes, then again, resort to the courts. The parties must still go to the courts to claim the rescission. Okay? Now let's go to another concept, no? Again, the right to rescind is not absolute. Here's another limitation, no? Only the injured party may ask for rescission. And even if this right to claim rescission is granted to the injured party can only bring rescission if he is ready, willing, and able to perform his part of the obligation. In other words, there can be no rescission if the injured party is not able to comply with his part of the obligation. Okay? Finally, this is a very, very important concept for the main topic that the right to rescind is not absolute. Okay? Rescission will not be permitted for slight or casual breaches, but only for such breaches as are so substantial or fundamental as to defeat the purpose of the parties in entering into the agreement. In other words, in short, okay, in order for a party to properly claim the remedy of rescission, the breach must be substantial. Okay? And how do we know if the breach is substantial? It's simple. Did it defeat the intention of the parties or the object of the parties in entering into the agreement? If their intention is defeated, if their object is defeated, and then that we can now say it is substantial. Okay, in some cases, the court has denied the remedy of rescission. If, like, let's say, out of 50 goods to be delivered, 49 were delivered. That may be considered a slight breach. Okay? So there has to be substantial breach. Okay? Now, let's move on to the next concept. The right to rescind may be waived. Okay? The waiver may be done orally or it may be done expressly. Okay? And now we can go to the effects of rescission. First of all, easy, no? Rescission extinguishes the obligation with a retroactive effect, going back to the time of the constitution of the obligation, making it as if the parties never entered into the obligation at all. And because of that effect comes the second effect, which is actually a duty, the duty of mutual restitution. Under the duty of mutual restitution, each party is bound to return whatever he may have received by virtue of the obligation. In other words, if one party had received the object and its fruits, he must now return that object and its fruits. And the other party, in case he has received the price and its interests, must return that price and its interests. Okay? So, now let's talk about some instances when rescission cannot be claimed. Okay? First, I mentioned this earlier, no? Rescission cannot be claimed if the party who is asking for rescission is not ready to comply with what is due from him. Okay? It cannot also be invoked if the party who is asking for rescission cannot return what he has received by virtue of the obligation. In connection with that, rescission cannot be claimed if the thing subject of the obligation is now in the possession of a third party who has acted in good faith. So what's the remedy in that case if it's with a third party? The remedy of the injured party is to go after the party at fault for damages. Okay? And finally, there can be no partial rescission, as rescission must involve the entire obligation. Okay? So that's it for rescission. Please just remember those very, very important concepts. Okay? So I hope you have picked up a thing or two, and I hope to see you again. Bye!